It's a great honor to be here. So the topic I'm talking about today is an EU topic, but it's also an international law topic if you want. It's about European Union investment policy, and it's about several judgments in particular of the European Court of Justice in recent years, in the last year or two, that have potentially significantly limited the ability of the European Union to enter into investment agreements, to adopt rules about investment, and in particular about investor-state arbitration with third countries. So I'm going to talk about those. So what's the starting point? The EU is a huge source and destination for FDI. Actually, it's the largest in the world. It has the largest inward and outward FDI stocks in the world currently. The EU is itself built on the protection and liberalization of investments. Right? So the EU internal market rules on freedom of establishment, on free movement of capital, in a way that's investor protection. Right? And the whole EU legal order was built on those rules. The EU has exclusive competence over commercial issues, over commerce with third countries. It's had that since forever. And yet, only in 2009 did the EU, with the Lisbon Treaty, get an explicit competence to address foreign direct investment. And yet, to this day, the EU has not been able to actually conclude an investment agreement with a third country. And only in the last year or two have we begun a discussion before the European Court about what this EU competence about investment actually means. How far does it extend, and what the EU can do and how. And one particularly important issue related to those two questions is investor-state arbitration. Can we have investor-state arbitration in the EU, and can we have it between the EU and third countries? So this is a discussion that's ongoing right now. So there are three important judgments, two of which already came down, 2017 and 2018, and the third one that is pending. The first one, the European Court of Justice opinion in Singapore, so the opinion about the proposed trade and investment agreement with Singapore, where the court dealt with EU competences on investment. The second one is Achmea. It's a judgment where the court dealt with the legality of investor-state arbitration clauses in intra-EU BITs, so investment agreements between two EU member states in which investor-state arbitration was included. And the third one, arguably the most important one that we're just waiting for now, is about CETA. CETA is the trade and investment agreement between the EU and Canada, the proposed agreement, I should say. And the question is, can we have investor-state arbitration in an agreement with a third country? So is that legal? So the first one is about competences, the second and the third are about legality. So starting point is Article 3, Article 207 of the TFEU, the Treaty on the Functioning of the European Union, which tell us the EU has exclusive competence over so-called common commercial policy, so commerce with third countries, and that includes foreign direct investment. Now, when you read that provision, you might think, well, obviously, the EU can then go ahead and conclude a treaty that has investment provisions in it, investor protection provisions, such as fair and equitable treatment and so on, and that has some sort of dispute settlement. Right? It says so right there. But it wasn't so clear, and it's not so clear now. And the European Commission, to get some clarity on that, sent a request for an opinion to the European Court of Justice, using its proposed agreement with Singapore as sort of test case. And the question that the Commission asked was, can the European Union conclude this agreement on its own? These are the key words, on its own. Now, why are those the key words? The Commission wanted to avoid, by the way, I should have said before, I work for the Commission, but I'm speaking purely in personal capacity here. So these are not, I'm not giving you the Commission line necessarily. So the Commission wanted to avoid so-called mixity. Mixity means, or mixed agreement, that you conclude an agreement together with all of the EU member states. So on one side you have EU and 28 member states. On the other side you have, for example, Canada or Singapore. Okay? Now the obvious problem with Mixity is you need 29 ratification procedures. You need at least 28 member state parliaments, possibly even referenda. In some countries there is more than one parliament, and that's especially important in Belgium, which has sent the request for the opinion in CETA that I'll talk about later. So Mixity is difficult. It might give the European Union a sort of an upper hand in negotiating because, well, the EU can say, listen, I can't agree on that because Belgium doesn't let me or Slovenia doesn't let me. But it also creates a sort of credibility problem. If you negotiate an agreement, everything is fine, and then it's blown up at the last moment because of a particular member state, because of political concerns happening there. Yeah? So what the Commission wants in order to have an effective investment policy is to be able to conclude these agreements alone. To get there, the Commission needs exclusive competence. Because exclusive competence means no member state involvement in the ratification of the treaty. Okay? Now, if the court were to say that something in that agreement is a shared competence, okay? Shared competence means both the EU and its member states in principle can act. Now, if something is shared competence, legally speaking, that could also mean that the EU concludes the agreement alone, but in practice, as long as it's not exclusive competence, politically, we go for the mixed agreement route. Okay? So this is why the Commission was really keen to get to exclusive competence. And it got there, almost. Right? So surprisingly to many, in terms of substance, almost everything covered by the Singapore Agreement was considered to be exclusive competence. Even things like transport policy, environmental sustainability, labor rights, which are generally not considered to be exclusive competence and not considered to be a part of the common commercial policy. For all of those things, the court said, fine, you have exclusive competence there. However, it excluded two areas which are especially important for us now. One of them is portfolio investment. So the provision we were looking at before only talks about foreign direct investment. The court says that does not cover portfolio investment. If you want to go after portfolio investment in a treaty, it has to be a mixed agreement. And the other point, even more important, is investor-state arbitration. Now, the traditional view would be, if you have competence, exclusive competence over the substance, so over foreign direct investment, for example, the institutional competence follows automatically. It's an accessory. So if you can have FDI in a treaty, you can also have dispute settlement in that area in the treaty. The court doesn't go that way, rather surprisingly and tellingly, given the judgment in Achmea later on. The court says you cannot agree investor-state arbitration without member state consent because investor-state arbitration removes disputes from the jurisdiction of national courts. Therefore, this is not exclusive EU competence. Now, you might say, obviously, investor-state arbitration removes disputes from the jurisdiction of courts. That's what it's meant to do. Yeah? But for the court, this meant that it's a shared competence. And the court then also said, if it's a shared competence, you cannot, the EU cannot conclude the agreement on its own. And this is significant because what we thought before was just a matter of practice and policy, that in the area of shared competence we go for mixed agreements, now seems to be a legal requirement. So as long as there's one drop of possible, even theoretical member state competence, even where the EU also has competence, the agreement has to be mixed, meaning you need ratification by 28 member states. Now, the Commission has taken this to heart, and it has done what many have foreseen that it would do. So it's begun to reformulate its trade agreements so that they only cover the areas where the court said there is exclusive competence. So this is what happened right now in the most recent version of Singapore. in the version of the agreement with Vietnam, some others, I believe, also that are signed or about to be signed. So they don't include portfolio investment, and they only include state-to-state dispute settlement. No more investor-state arbitration. If someone wants to do it, they have to do it through a separate mixed agreement. Now, what the court also said, and this is very important, the issues that we discuss here in Singapore are issues of competence, so it's about who can do it. We are explicitly not talking about legality, whether it can be done at all legally under EU law, whether it's legal to have investor-state arbitration in an EU treaty. Now let's pause here and think for a moment. Is this odd? How can you discuss who does it while leaving open the question of can it be done at all in the first place? Is it legal? Right? If something is illegal, then the EU cannot do it as a question of logic, right? So it's a bit unusual and I think telling that the court makes this statement. And indeed, the question of legality popped up soon enough, several months later, in a preliminary reference, so a reference from a national court to the European court, which was about whether or not investor-state arbitration in intra-EU BITs is legal. Why would it not be legal? There are several possible arguments. You could say that these intra-EU investment treaties impinge on EU competences on investment. You could say that they overlap in undesirable ways with EU law, with EU rules about internal market, free movement of capital, and so on. You could say that they are discriminatory because they put some EU investors in a better position than others. So if you happen to be based in a country that has a bid with the host state, you're treated better than another EU investor. Right? Remember, this is not about third country investors, this is about EU investors. It's an internal matter. There's the possibility of conflict with state aid control. Right? So when an EU member state gives a subsidy, the Commission may decide that that subsidy or state aid is illegal, that it has to be withdrawn. In these cases, some investors have went before arbitration, investment arbitration, and argued that the withdrawal of the aid was tantamount to expropriation, and they got damages. The Commission doesn't like this. The European Commission doesn't like this. So this is another reason why it opposes intra-EU BITs. But the reason that was, in the end, the most important one, the one that was addressed by the court, is this question of the autonomy of EU law. Right? And the notion is the relationship between the member states, the division of competences between the EU and its member states, the interpretation and validity of European Union law. These issues cannot be decided by an investment arbitrator. They need to be decided by, ultimately at least, by the European Court. That's sort of the idea of the autonomy of EU law. You cannot take something that's at the same time a European Union law question and decide it in a parallel adjudication system, so to say. Okay. So the facts in Achmea are relatively straightforward. Dutch investor relies on the Netherlands-Slovakia BIT from 1991. So almost all of these intra-EU BITs were concluded between a Western European and an Eastern European country before the Eastern European country joined the EU, and they stayed in force even after accession. So this was the case here, Netherlands, Czech Republic, and Slovakia BIT from 1991. This agreement provided for uncitral arbitration, so not ICSID. That's relevant. Achmea won an award against Slovakia in the amount of 20 million euros for its rollback of the liberalization of the health insurance market. So the market was liberalized, Achmea went in, after a few months the liberalization was annulled, and this violated, apparently, the rules in the BIT. So the place of arbitration was Germany. A German court was deciding on the enforcement of the award against Slovakia. And in the context of those enforcement proceedings, the question came up, well, is the BIT, and especially its provisions on allowing for investor-state arbitration, contrary to European Union law, meaning that it could not be enforced? Okay. And this question ultimately comes by way of reference to the European Court of Justice. More specifically, the question is as follows. In the context of this autonomy of EU law argument, what we have here, essentially, is a dispute between two member states. Now, it's an investor versus a state, but the bottom line is it's an intra-EU dispute between two members, and there is a provision in the EU treaties that says member states undertake not to submit any dispute concerning European Union law to any form of dispute settlement other than the European Court of Justice. Okay? So that's one problem. The other problem is the ability of courts to make a reference to the European Court, the ability of national courts to make this reference, is jeopardized potentially by recourse to arbitration because it circumvents the mechanism. So the Advocate General, this is a sort of an advisor to the court, a member of the court, but not a judge, rather than an advisor to the court. He thought the intra-EU BITs were fine, that there was no illegality. Most of all because, well, this is not really a dispute between member states, but between an investor and a state. And secondly, there is no problem with the ability to refer to the European Court, to refer EU law-related issues to the European Court, because, well, these arbitrators are like courts anyway. They are permanent. They are set up by a legal instrument. They have mandatory jurisdiction. So we should treat them as courts, integrate them into our judicial systems under EU law, and allow them to refer to the European Court. Now, if you're at all familiar with the world of investment arbitration, you know, this very idea that an arbitral tribunal would pass the ball to a national or even European court when deciding an investor-state dispute is a little bit bizarre, right? Because, again, the whole idea of having recourse to investment arbitration is to avoid courts. Okay? But still, the Advocate General tried to construct this solution. Now, the court took a different route, and it basically struck down these provisions totally. All investor-state arbitration provisions, essentially in any conceivable intra-EU BIT. So the court based itself mostly on this idea of the autonomy of EU law. So what is the autonomy of EU law? Basically, if I can summarize it a bit freely, it's what makes the European Union special. All of those things that make the EU into more than an international organization. And what are those things? Well, first of all, the notion that EU law has direct effect before any member state authority or court, that it has primacy, so whatever national constitutional law says, EU law is always hierarchically superior to national law, that it lays down certain common values, including human rights, and that it has this idea of mutual trust. And that's especially important in this context. Mutual trust, meaning that member states recognize each other as legitimate regulators, so to say. You see this in internal market law, right, with the notion of mutual recognition of products being admitted into markets. But you also see it in things like criminal law, where you have mutual recognition of judgments, where you have European arrest warrants being executed. The idea is EU law creates a system that guarantees a kind of mutual trust between the member states. And when you have additional rules bilaterally concluded between the member states in the same or in a similar area, that undercuts or undermines that system of mutual trust. There's also a procedural angle to that, right, to the substance of autonomy of EU law. The procedural angle is that there is a sort of a network of national courts which apply EU law, with the European Court sort of at the top, giving a mandatory final interpretation of what EU law means. There is a kind of judicial dialogue going on within this network. And in order to preserve the specific characteristics of EU law, this monopoly of the European Court and this dialogue between the European and national courts need to be preserved. Right? So that's kind of the background of what the autonomy of EU law means. More specifically, the court translates all this into a very simple test, strikingly simple test. So the court asks basically three questions. First, do these BIT, intra-EU BIT investment arbitrators apply or interpret European Union law? And here the answer is quite simple. They do because the BIT says so. In the BIT, the applicable law is Slovak law and, of course, the BIT itself and other relevant rules of international law enforced between the parties. So European Union law, and this tells you again a bit about what an unusual animal this is, European Union and European Union law. At the same time, it's a part of Slovak law, internal domestic Slovak law, and an international agreement valid between Slovakia and the Netherlands. Right? So on both of those scores, the EU law is a part of the applicable law in the dispute. So first question, easy. Second question, are the arbitrators a part of the EU judicial system so that they could, for example, refer to the European Court of Justice, refer questions of interpretation to the European Court of Justice? And the court says, no, and that's the point. They're specifically designed not to be a part of any national judicial system, and they cannot send any questions to us because they're not a court. And then finally, is there any kind of judicial review of their decisions by either EU or national courts? Is that review effective? The court says basically no. First of all, the parties can agree on any country, even a non-EU country, as the seat of the arbitration. So you could go to Singapore, to Dubai, and have arbitral proceedings under this BIT, and there would never be a situation in which a European court could enforce that award, probably. Even if you have the arbitration in the EU, the control of that award at the stage of enforcement is very limited to a sort of public order exception. And to say nothing of the fact that if this was an ICSID arbitration, which it is not, but if it was an ICSID arbitration, you wouldn't even have that. You wouldn't even be able to examine the award for public order concerns at the enforcement stage. So the court says we have here a system where the tribunals interpret or apply EU law, specifically as part of the applicable law. They are not part of the EU judicial system, and there is no effective judicial review. Therefore, having this in an intra-EU BIT is contrary to the autonomy of EU law, and it's illegal. So what's striking about this reasoning? It's striking how simple it is, and it's striking how broad it is. Because if you really take it at face value, if you take literally what the court says here, it's hard to imagine any international dispute settlement in any treaty, essentially, that would survive, right? Without having built into the system a kind of recourse to the European Court. That's a bit the problem of this reasoning. So the court doesn't talk at all about, the problems that, many of the other problems that the European Commission, for example, sees with intra-EU BITs. So the fact that there's discrimination between different investors, there's an impact on EU competences. Doesn't talk at all about the relationship between the content of the BIT and the content of EU law, and whether there is some undesirable overlap. Puts all that to one side. It just talks about, disputes are taken away from courts. There's no guarantee of the effective application of EU law. And that's it. Now, another interesting thing that not many people have noticed, around the same time that Achmea came out, there have been a number of judgments of the European Court talking for the first time about this rather innocuous sounding provision of Article 19 of the European Treaty, which says member states have to provide sufficient remedies to ensure effective legal protection in the fields covered by EU law. Now, this is cited a lot in the Achmea judgment itself, and it shows that the court is not just talking about its own interpretative monopoly, but in a way it's talking about some notion of an EU rule of law. Right? And you see this in these judgments. So the Portuguese Judges case is the first case where the court said that Article 19 is not just about specific remedies. So a member state has to provide, for example, the access to a court in order to be able to challenge something on the basis of EU law. But it's also about the structural features of that member state's judiciary. Things like judicial independence. This was applied just a few weeks ago, in this case, Commission versus Poland, where the court did an amazing thing. It adopted an interim measure basically requiring Poland to roll back the retirement of its Supreme Court judges. So Poland adopted a law which retroactively requires Supreme Court judges over a certain age, arguably because of political motivations, because it wanted certain judges out, to retire. The Commission challenged that as a violation of the rule of law in very, very general terms, and it got an interim measure in that case. Also, Commission versus France, a recent case, the Commission managed to persuade the court that a member state infringes EU law because its Supreme Court failed to send a reference to the European Court of Justice on an issue of EU law. So what do we see here? We see here a kind of a rising trend of creating something like a European rule of law principle. It's not just about specific remedies and the effectiveness of EU law, but it's bigger than that. It's about the independence of the member states' judiciaries. And it's about strengthening this network of national courts and the European Court. So it could be that Achmea is a kind of collateral damage. Right? So intra-EU investor arbitration is collateral damage of this bigger idea. Okay, so after the Achmea judgment, it's not yet fully clear what the landscape is going to be. The Commission thinks this is great. Now we finally have proof that all of these intra-EU BITs are illegal, that they have to be set aside. There is no valid consent to arbitrate. If you want to enforce an award, you cannot, because it's contrary to EU law. And member states must terminate the existing BITs. Investment arbitrators have a slightly different view. So in the cases we've seen so far, they have tried to distinguish on numerous grounds from Achmea. So they said, well, but this does not apply to Energy Charter Treaty arbitrations. This does not apply to ICSID. And by the way, we prefer the reasoning of the Advocate General. From the EU law point of view, at least, that reasoning is not very convincing. I think really there is no way to say that the reasoning in Achmea excludes some types of investment arbitration in intra-EU bits. Okay, so now we come to strike three, or the potential strike three, which is the CETA case. Now, CETA, of course, is the proposed agreement between the EU and Canada. It's a mixed agreement, so all of the member states are supposed to ratify it. What's specific about it is that it has a new type of investor-state dispute settlement, something that the EU calls an investment court system. So instead of ad hoc arbitration, there would be a permanent roster of tribunal members from which a tribunal would be constituted, and there would be an appellate jurisdiction, essentially. Now, as a condition for provisionally signing the treaty, Belgium has required an opinion from the court about the validity, the legality of investor-state arbitration in that treaty. And it's focused mostly on the same issues that Achmea was dealing with. So the autonomy of EU law and the exclusive jurisdiction of the European Court to interpret European law, but also on the question of non-discrimination. And there are also some concerns raised with the way the investment tribunal, the dispute settlement tribunal, is designed. But I'm not going to go into those. Now, how is CETA different from the bit that the court struck down in Achmea, other than the fact that it's an extra-EU agreement, not intra-EU? There are several provisions which try to hedge for some of the problems the court saw in Achmea, but also in other previous cases dealing with this notion of autonomy of EU law, most notably Opinion 2, 2013, where the court said that the EU cannot accede to the European Convention on Human Rights because of the potentially binding jurisdiction of the European Court of Human Rights over European Union law issues. Right? So CETA tries to distinguish itself. Now, one of them is the tribunal cannot determine the legality of a measure under a party's domestic law. It only considers domestic law as a matter of fact. It has to follow the prevailing interpretation in the EU, for example. And it can never, ever require the repeal of a measure. The only thing it can require, well, this is not really unique. This is the case for any investment agreement. It can only impose damages, essentially. You can still go on and do whatever it is that EU law requires you to do. The worst thing that can happen is you can pay damages. Of course, those damages, as we all know, can be quite substantial, and they do create a significant pressure to change the law that is at issue. Okay. Now, a lot of people have discussed whether CETA is different along these lines. So unlike Achmea, EU law is specifically, explicitly not the applicable law in CETA. It's only a fact. So this is kind of the orthodox position in international law that we know from the Permanent Court of International Justice back in the 30s, which says, from the point of view of international law, municipal laws are merely facts. So there's nothing innovative about CETA in this respect. But of course, this dividing line is quite blurry. And I give you here two examples. One is an investment arbitration in Ancana Corporation versus Ecuador. And the other is a WTO appellate body decision in a case called EC Seals. Now, in the first case, the tribunal looks at Ecuadorian law as a matter of fact, but it then has to decide, in order to decide whether there was expropriation, whether there was initially a right under the law of Ecuador. Okay? So here, the law of Ecuador is clearly a fact, but you're still necessarily interpreting it, giving meaning to it. There's no way around it, right? Because you have to know what happens under the national law that is being challenged. Same thing in EC Seals. The appellate body looks at an EU regulation, what specifically it does, and comes to the conclusion that it's not concerned with a product ban, but about imposing certain conditions. Same thing. You look at the law as a fact, and you give it some meaning, and then you legally characterize that meaning. So the point is, even when you are looking at a law only as a fact, you're still, in a way, interpreting that law. Now, of course, on the other hand, from the point of view of arbitration, it's very important what the applicable law is. And I think, a litigator in that context would try to draw a clear line formally between something that is applicable law and other laws that are not applicable law. And there is some relevance in this distinction, even if it is quite formalist. So I want to wrap up with the following sort of questions for discussion. I'm not sure how much time we will have for discussion, but still just to raise them. Is there a way for CETA, for investor-state arbitration in CETA, to survive after Achmea? Most people would say no. And that's because of the way the court has formulated Achmea. Because it's so simple, so straightforward. You're dealing with interpretation of EU law. You're taking disputes away from national courts. There is no review by the ECJ. Therefore, it's illegal. What I would suggest is that maybe, even if it would be a little bit incoherent, the court could still distinguish by focusing on different factors in CETA. One of them is, it's not internal, it's external. If you read both Achmea and the opinion about the European Convention on Human Rights, what is the problem that intra-EU bits pose? It's not jurisdiction. It's about the fact that member states create a parallel system of rights and obligations and a parallel jurisdiction to deal with something that EU law is supposed to deal with. EU law is supposed to give you guarantees for investment in another member state. EU law is supposed to give you a system of remedies. And we see now that there is growing case law where the court is trying to strengthen, through this notion of rule of law, that system of remedies. So in a way, what intra-EU investment arbitration does is it undercuts that system. It undercuts the idea of mutual trust. And these things are simply not relevant, or not as relevant, when you're talking about extra-EU arbitration between, let's say, a Canadian investor and a host state in the EU. Also, simply formally speaking, Article 344, which is about member states not submitting disputes between them to any other jurisdiction but the ECJ, is not relevant. So I think what the court is fundamentally concerned with is that this fragile and still not sufficiently well-functioning system of rights and remedies within the EU is being circumvented, is being layered on top by something else. And I think that concern doesn't really exist with respect to CETA. Another problem is the impact on all other investment agreements. So the EU hasn't ratified much, but there is about 1,500 member state investment agreements with third countries. Now, if CETA is illegal, or if arbitration in CETA is illegal, then the same is true for all of them as well. So if the court simply carbon copies the Achmea reasoning into CETA and says no arbitration, that basically means no investment arbitration ever in any dispute involving an EU member state. Now, that's a pretty huge consequence, and I'm not sure the court wants to draw it. And then finally, and I'll stop here, the court may want to finally draw a line. Right? Because again, if you copy over the Achmea reasoning, it's very hard to see how any international dispute settlement body could survive. Because whenever you are dealing with the compatibility of EU law with a treaty, you have to sort of interpret that law. And without sending a question to the European Court of Justice, you're doing this outside the EU judicial system. So even something like the WTO dispute settlement system would be problematic, right? Because it does the same thing. So the court may want to draw a line, and this may be the place where it draws it. And I think there may be significant or sufficient reasons to distinguish CETA from Achmea. So I still think that the more likely outcome is, unfortunately, maybe, that the court will follow the consensus view, that it will say that arbitration in CETA is illegal as well. But if I was betting, I would take those odds, that it might still distinguish. And I stop there. Thank you.
Nico has a question right away. Thank you very much for the talk. Just to pick up on your last point, you said, well, the external versus internal distinction seems to be more important in CETA than in the EU. But let's say, when a Canadian investor...
I can because there's nobody can.
All right. When a Canadian investor... Okay, speak. All right. When a Canadian investor establishes itself and incorporates a company in the EU, I see that distinction sort of blurring a lot.
Yeah, no, you're absolutely right. And actually that's the reason why Belgium, in its request, focuses specifically on that situation. So they're saying, is it illegal because it puts the subsidiary of a Canadian investor in a better position than another EU investor? It's true. Yeah? It's true, because there you have then a problem of, well, it's sort of an intra-EU dispute, formally speaking. Yeah. Yes. But you could still distinguish it because by saying that in the background there is a Canadian investor. The point of internal versus external, quite frankly, it's a contextual point. Huh? And you can find little contradictions like that because there's so much overlap between EU law and international law. And another point along similar lines, CETA says the tribunal does not apply EU law, it only applies CETA, right, as applicable law. But of course, if CETA is ratified, then CETA is EU law. Exactly. Just like the GATT is EU law. So that's why I put up here logic versus context. It is a little bit incoherent, but I think contextually there are still some reasons why it could be distinguished.
Clemence.
Thank you so much.
There's another question. One.
First, I just want to thank you so much for this really clear explanation. So what I think is most interesting in the relationship between Achmea and CETA is that, in a way, the Commission kind of sets its own trap, because for years they opposed intra-EU bids and ISDS between member states. So the ECG, the Commission went before the ECG in the Achmea case, advocating for the suppression of ISDS, and now comes back in the extra-EU context, advocating for a multilateral court system. So I find interesting how they try to justify how it is relevant in the extra-EU context, but not in the intra-EU context. So that's the first thing. The second thing is, I think the bottom line of the resemblance between Achmea and CETA is the question of interpretation, the question of how the SDS might have to interpret. I mean, the CETA says that EU law will only be taken as a matter of fact and that they should rely on the prevailing interpretation. But what happens when there's no interpretation given by the ECG yet? That's a case. So if the CETA system gives an interpretation because the ECG has not taken position on it, there's going to be two parallel interpretations that might be different, and that can be a problem for the uniformity of EU law. So that's I think, is a question that is not resolved in the position of the Commission, and that can, more than the Achmea test, undermine the validity of the CETA system before the CETA decision. So that's my one thing. And another thing that I still don't understand is, to me, the protection given to investor at the EU level is not the same as the protection given by international law, because in the EU level you don't have the same substantive protection, you don't have FET, you don't have national treatment. So that, for me, is the strongest argument in favor of an ISDS, because they don't provide, they simply do not provide the same protection to investor than the EU system does. So I think that's one thing I haven't heard a lot. Thank you.
Okay. Should we take the other question? Or
I just wonder, from the point of view of the investors, this scenario is very risky. So I'm curious, what are the measures that the European Commission is analyzing or studying to give some certainty for investors, even in extra EU bids and in those scenarios that you have commented, if there are some particular measures?
One quick question on what your views were on the impact on contractual arbitration. So let's say the Belgian investor, the Belgian investor had signed a contract with the relevant Slovak state entity, and they said, let's go to arbitration in Germany. The arbitrators would have not, applying the Achmea test, they would have not been part of the judiciary system. they would have been applying Slovak law as infiltrated by EU law, and certainly the parties could have contracted out for any sort of they could have waived their right to have it reviewed by the national courts. Do you see that also at risk as a result of that decision?
Maybe it's easiest if I go backwards. So on that last question, I think contractual arbitration should be fine. There is a point in Achmea where the court talks about it. There is some case law from before saying that if you have arbitration in which EU law is applied, and the only judicial review over that, so standard commercial arbitration, in which EU law is applied, and the only judicial review is public order control at the stage of enforcement. The court said, well, this is okay, because ultimately there is some judicial review. But then it contrasts that with investor-state arbitration, which is somehow based on a treaty, on a broader consent, treaty between states, and somehow for the court that is relevant in saying that for Achmea there is a problem, whereas for commercial arbitration the problem is not there. I'm not sure how coherent or convincing that argument is, but it seems that commercial arbitration is fine. I'm not sure what it would mean for something that's in substance investor-state arbitration, but it's just based on a contract. I'm not sure where that fits between those two. So on the question of measures protecting the investors' legitimate expectations and so on, I mean, CETA has, not CETA, but CETA actually as well. It has provisionally entered into force, but without the investment provisions. Right? So, as a matter of fact, right now, Canadian investors, other investors, they cannot go to arbitration in the EU. So we're still waiting on what the court rules in CETA, in essence, so there's no particular measure being taken right now. And then finally, on your questions, yes, incoherence between the position in Achmea and CETA. So there was incoherence in the Commission's position on intra-EU bids, because years ago the Commission liked them, the bids between, let's say, the Netherlands and Slovakia. It's true, the Commission walks a very fine line there, and what it has to do now is distinguish. And I think a bit of a problem for the Commission is the way the court decided, because the arguments of the Commission were broader. There weren't really so much focused on this simple point, where you take disputes away from the jurisdiction. Then the second question was, interpretation. There was interpretation. True. I guess the point for intra-EU bids is it's equally weird as it would be weird for a Wisconsin investor to sue the state of Florida seeking damages in the U.S. legal order, right? So that's this. The EU has a problem with that for the same reason that the U.S. would have a problem with that internally. Whereas externally, your remedies, what you have available to you are much less still. Now, of course, there is a difference being able to invoke an investment treaty and all of these other things, but it's a question of degree, I suppose.
There's one last question over there.
Thank you for your presentation. I was wondering which is your opinion and the opinion of the Commission about a multilateral investment court. Because one of the features, I think one of the genesis of international investment state arbitration was to avoid going to courts because investors were seeking a neutral forum. So what's your opinion and the official opinion of the Commission? Thank you.
I think the official opinion, at least, is pretty clear. The Commission likes the idea of multilateral investment court. That's what they're trying to do, even in CETA. There is a provision saying, this is the ICS right now, tribunal with an appellate jurisdiction, but we would like to work towards multilateral court. And there's been some activity already in UNCITRAL, initiated by the EU, who work towards that. How likely it is that it happens anytime soon, I'm not sure. And my personal opinion on this, I think in the long run it might be a good idea to have a more permanent mechanism. Yes. But right now I think the EU first needs to get its house in order with CETA. And we need to have some clarity about what can be done, what can't be done. And I'm not sure even a multilateral system like that would satisfy the requirements of the European Court as they seem to stand now. That's a bit the problem. So yeah, first things first.
On this note, thank you very much. Give it up for Mislav Mataija.
Thank you.
Thank you.